Hello, I'm Dominic Walker, JMW's Inside Man. My guest today is Alex Streeter. Alex is a solicitor within JMW's private client department. And Alex, families come in all sorts of different shapes and sizes nowadays, and it's not unusual for children to have step-parents. But what would happen if a step-parent was to pass away and there was no will in place?
Well, I mean, as you say, Dominic, we are seeing kind of a growing increase in families with different setups. Stepchildren are regularly involved. And in the event that that couple are married, on the first death, if there's no will in place, the vast majority of that estate is going to pass to the surviving spouse. The result of that is the surviving spouse's children, so first to die stepchildren, are going to be the ultimate beneficiaries of that estate. Again, this means that the first to die, who may have children of their own, without a will in place, it's likely that they're going to receive very little from their parents' estate, and instead it will pass to their step siblings via it being, their parent that's been the first person to die. So, while stepchildren aren't included kind of in the laws of intestacy, the way that it works, kind of passing to your spouse first, it is likely that those stepchildren, rather than your own children, are going to benefit from your estate. So, anyone with those kind of family circumstances, it's important that their will, is first of all in place, but deals with that situation.
So is it important then to make a new will when you get married?
Yeah, I mean, depending on the circumstances, Dominic, it could be incredibly important. If you have a will in place already, the marriage automatically revokes that will. So if you were to pass away without a new one in place, the will you've previously set up is irrelevant, really, because it's been revoked by the actual marriage, and your estate will pass by the laws of intestacy, which, as we spoke about just now, could mean that the beneficiaries you had in your will, won't receive anything from your estate. Now, that's a particular concern when it comes to second marriages, as the will you've done previously may leave stuff to your children. And perhaps of equal importance is that getting divorced doesn't revoke your will either. So if you are divorced or in the process of getting divorced, the likelihood is you're not going to want your ex-partner to receive kind of assets of your estate. And it's important to get your will updated in that scenario as soon as possible, really.
And so you mentioned getting wills updated. It leads me naturally on to the next question, which is for anybody who would like to have a will drafted, what should they do?
Well, first of all, get in touch with JMW's private client team, of course, Dominic. We offer a free will consultation to anyone looking to put a will in place and provide them with all of the options that might be available to them, however complex their family setup is or financial circumstances are. Not having a will in place, which we see regularly, and our contentious probate team especially see regularly, can cause real upset amongst family members. So having a will in place, make sure your kind of loved ones are protected once you've left them behind, and would give you peace of mind to know your estate's going to pass exactly how you'd like it to.
Alex, thank you very much for your insight. And if you'd like to speak to Alex and the private client team, you can email insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.